Welcome to today's Explainer. Right now, we're going to unravel a high-stakes corporate drama that perfectly illustrates an absolutely foundational concept in law. We're looking at the fascinating Supreme Court case of the Makati Stock Exchange versus Miguel Campos. Now, this isn't just some minor, petty disagreement. We're talking about millions of pesos on the line, intense boardroom power struggles, and a fundamental legal mystery that forces us to ask, what actually makes a promise legally binding? You see, back in the booming stock market of the late 80s and early 90s, getting access to initial public offerings, or IPOs, was incredibly lucrative. So the stakes here literally could not be higher.
To set the stage, picture this for a second. Think about your own workplace. If your office has a normal practice of, say, giving out free coffee or maybe catered lunches every Friday for 5 straight years, and then management suddenly just stops doing it, can you sue them? It sounds like a pretty simple everyday scenario, right? But bridging that exact gap between a normal, customary practice and an enforceable legal right is exactly what tore the founding members of the Makati Stock Exchange apart. So, does a customary perk automatically become a legal right? Let's find out.
So, let's wind the clock back to 1989. The Makati Stock Exchange passed a formal resolution honoring Miguel Campos. He was their only surviving original incorporator, and to show their gratitude, they made him chairman emeritus for life. Now, for years, Campos enjoyed the massive financial perks that came with his position. Everything was going great. But then, fast forward to June 3, 1993. Out of absolutely nowhere, the board of directors abruptly passed a resolution to stop giving Campos his lucrative share of those IPOs. Just imagine getting that memo. Outraged by this sudden cutoff, Campos refused to just walk away quietly. In 1994, he filed a petition with the Securities and Exchange Commission, suing the board for damages and fiercely demanding his shares back.
The absolute core of Campos's argument rested on what he called a normal practice in the industry. He basically said, hey, I'm being illegally deprived of my right to participate equally in these IPO allocations. But here's the catch. His proof for this wasn't a specific contract or a piece of paper. It was history. Historically, 25% of all IPO shares were divided equally between the country's 2 stock exchanges. Those exchanges then took that chunk and divided it equally among their members, including him. All they had to do was pay the base offering price. Because this was practically guaranteed profit, Campos argued that this custom of allocating the 25% was so deeply established over the years, it had essentially transformed into a rock-solid legal right.
While the exchange's board fired back with a massive legal counterpunch, they filed a motion to dismiss. Their primary argument? They said Campos completely failed to state a cause of action. Now, in law, a cause of action is the act or omission by which one party violates the right of another. This is a critical threshold to cross. If you don't have a valid cause of action, your lawsuit is completely dead in the water before a judge even starts listening to your arguments. It essentially means that even if everything you are saying is 100% true, the law just doesn't provide a remedy for it.
For a complaint to survive that kind of motion to dismiss, you need 3 essential elements. First, you need the legal right of the plaintiff. Second, the correlative obligation of the defendant to actually respect that right. And third, the act or omission of the defendant that violates that right. So to solve our mystery here and figure out if Campos has a real case, we got to peel back the layers. Did Campos actually have legally recognized right to those IPOs? And did the exchange have a correlative obligation to hand them over? To answer that, we have to step out of the cutthroat boardroom for a minute and head into the classroom. Before we can rule on who gets millions of pesos in stock shares, we really need to understand the underlying theory. It's time to hit the books on the civil law of obligations and contracts. This is the absolute foundation, guys. It's the only way we can figure out who is legally in the right here, and whether a long-standing tradition actually holds up in the eyes of the law.
First things first, we have to define what an obligation actually is. By definition, an obligation is a juridical necessity to give, to do, or not to do. The absolute keyword in that sentence is juridical. It means there is a strict legal tie, a vinculum juris, that forces a debtor to act for a creditor. And if they don't, well, the creditor can literally go to court, utilize the power of the state, and demand satisfaction directly from the debtor's assets. So we're not talking about a friendly favor here. It's not a polite request. It is a powerful, binding requirement enforced by the state. Now, according to Article 1157 of the Civil Code, there are exactly 5 sources of obligations. Just 5. Law, contracts, quasi-contracts, delicts, and quasi-delicts. This is a closed list. For Miguel Campos to win his lawsuit and prove the board had a binding obligation to give him those lucrative shares, his claim absolutely must fit perfectly into one of these 5 specific buckets. If it doesn't fit, he loses the whole thing. Let's break these down quickly so we know exactly what we're looking for.
The first two sources are definitely the most common: law and contracts. Obligations derived from law or ex lege must be expressly or impliedly set forth by the state. You can't just presume them. Think of paying your taxes, right? You don't sign a contract agreeing to pay income tax. The law itself forces you to do it. The second source is contracts or ex contractuor. A contract is quite literally the law between the parties involved. When you sign it, you must comply with it in good faith, and neither party can unilaterally just walk away unless the terms of the agreement explicitly say they can.
Okay, the third source is quasi-contracts. These arise from lawful, voluntary, and unilateral acts, and they're designed specifically to make sure that no one gets unjustly enriched at the expense of someone else. For example, there's a concept called negotiorum gestio. That's when someone voluntarily takes charge of your abandoned property without your authority just to save it from ruin. Or take solutio indebiti. That happens when you accidentally receive a payment by mistake, money you had absolutely no right to demand. The law steps in and says, hey, you have an obligation to return that money even though there was no formal contract.
Finally, we have delicts and quasi-delicts. Delicts are civil liabilities that arise directly from committing an intentional crime, like a felony. If you steal a car, you obviously have an obligation to pay restitution. Quasi-delicts, which are also known as torts, involve a fault or an act of negligence that causes damage to someone else, even when there's no pre-existing contract. The main difference here is intent versus accident. If you're carelessly swinging a baseball bat and you accidentally break your neighbor's window, you didn't mean to do it, but you still have a legal obligation to pay for those damages.
So this builds to our ultimate legal showdown. On one side of the ring, we've got Miguel Campos. He's basing his entire claim on a normal practice, relying on this historical custom of distributing 25% of IPOs. On the other side, we have the strict legal requirement. Any enforceable right or obligation must be rooted in one of those 5 legal sources we just reviewed. Simply asserting that you have a right in a petition without identifying its specific legal source is just a conclusion of fact. It's not a valid legal claim.
Campos, probably realizing he needed a much better anchor for his case, tried pointing to the 1989 board resolution, the one that made him chairman emeritus. He argued, look, this resolution functions as my contract. Well, let's analyze that. The Supreme Court did a meticulous review of this exact document. It praised his unselfish service. It gave him a prestigious lifetime title. It granted him the privilege to attend all the board meetings. It even ordered a commemorative bronze plaque in his honor. But do you know what it completely failed to mention? IPO allocations. There was absolutely zero mention in that grand resolution conferring upon him the right to receive those shares. It just wasn't in the contract.
And that brings us to the Supreme Court's final mic drop verdict. They stated, a practice or custom is, as a general rule, not a source of a legally demandable or enforceable right. Because Campos's claim relied entirely on a customary practice, and custom is noticeably missing from those 5 exclusive sources of obligations under the Civil Code, he had no legally demandable right, period. The board had no correlative obligation to give him anything. He failed to state a cause of action, and his petition was completely and finally dismissed.
Now, before we wrap this up, I do want to share a crucial nuance, a sort of but wait moment. You might be thinking about your own job right now, wondering about employee bonuses or perks that have been around forever. And it's true, in labor cases, benefits voluntarily given by an employer that have ripened into company practice often cannot be diminished. But here is the fascinating part. Even in those labor cases, the ultimate source of the employee's right is not the custom itself. The source is the law. Specifically, Article 100 of the Labor Code, which explicitly prohibits the elimination or diminution of benefits. Without that specific law backing it up, the custom alone would mean absolutely nothing. And unfortunately for Mr. Campos, there was no equivalent law protecting the perks of stock exchange members. So let's summarize the core takeaways from today's explainer. First off, a normal practice or custom, no matter how long it's been going on, is not a legal right on its own. Second, for an obligation to be enforceable in court, it absolutely must be rooted in a strict legal source, like the law itself or a formal contract. And third, and probably most practically for all of us, if you want to guarantee a corporate perk, do not rely on a handshake, good faith, or the way things have always been done. If you want to protect your interests, you have to get your perks written into a formal, binding contract.
Which leaves me with this final question for you to ponder today. Take a hard look at your own professional life. Are your workplace rights and the perks you rely on every single day actually protected by a solid contract? Or are they just a custom, waiting to be canceled at the next board meeting? It's definitely something to think about, right? Thank you so much for joining me for this explainer, and I really hope this gave you a whole new perspective on the true power of obligations and contracts.